Hello everybody and welcome to the first part of what is a series of law of contract tutorials. So I will mainly be teaching to the OCR A Level law specification. You'll see on the screen here that law of contract makes up 75% of what is component 4 and is worth 60 marks. But this tutorial will also assist those of you who are studying other specifications and also contract at university as well. So I'll split law of contract, I believe it splits quite nicely into 7 areas here. The first being the rules and theory around the law of contract, and I think that this is a really nice area that can be read up on, looking at some of the key principles like the fairness of entering into a contract, the freedom and the ability for everybody to enter into a contract. You'll see that through the principles of contract law, and I have to say mainly this is what we call a common law area principles created by judges, you'll see that a lot of these areas are based around fairness and morality to a certain extent. The idea that a contract can be voidable if somebody has either told you an untruth, which has encouraged you to enter into that contract, or even if their silence has misled you in some way. You've got the other factor here, economic duress, where you might feel forced or pressured illegitimately to enter into a contract, and the courts will protect you in that way. So throughout this, please do keep an eye out for those principles, because certainly these can help you to formulate arguments for your nature of law essays, which is the other part of component 4 and also component 3 for those that are studying human rights instead. So I'm going to start in this tutorial with talking about how a contract is formed, which is of course our first step. Courts may be asked to decide whether a contract even exists. And let's all be clear that a contract is, for the main, a written agreement between parties. But contracts in our legal system, England and Wales, can also be oral. And of course, the difficulty with those is evidentially trying to, for the courts to find out what has actually been agreed as part of discussions. So after looking at whether a contract exists and who is party to a contract, we will then look at what is inside a contract, what is included as a term, what could be implied by the courts or by Parliament to be terms if they are missed out, either intentionally or accidentally. And then we'll also look at the types of terms that can exclude liability, so those terms that a business might want to put into a contract to protect themselves. We'll then look at some factors that may void a contract and how we can discharge our obligations under a contractual agreement as well. And then finally, remedies. So I would start by just showing you this visual. I see contract as a little bit of a story, an easy process flow, if you like, because we can start with whether a contract exists, and then we look at inside the contract, what are the terms to that contract. And then you can go on the right here, are there any factors that could void that contract? And we look at 2 factors on the OCR A level, but there are more out there. And then finally, has the contract come to an end? And for most contracts, they will come to an end because the contract has been performed. But what happens if performance hasn't been full, if only part of a contract has been performed? Then we may be looking at remedies for a breach of contract there. Contracts can become frustrated, which means they are unable to be performed. And this is usually an area which is not at fault of either party. It's just something that unfortunately has happened, maybe illness or something outside of the party's control that could not have been foreseeable. So that's a really nice area to look at as well. And again, another area that enables parties to try and be compensated for potential losses to that date, but it's not a punitive area. This isn't about punishing parties. if a contract genuinely cannot be performed. Okay, so we'll start with the basics. What is the law of contract? So this area is about providing protection for those who are party to a contract. And as I've already mentioned, a contract can be described or defined as an agreement which is enforceable by law. It can be written, oral, or both. Contract law, we find the principles largely based around common law. So those are our judge-made principles, our precedents that we follow. But we do have acts as well, particularly in relation to the protection of consumers. Certainly on the A level, this is an important area. So we're all consumers in our daily lives, and Parliament have legislated some key protections for us, giving us right to refunds, repairs or replacements of goods and services that we choose to consume. And the main underpinning theory, I would say, really around the law of contract is the theory of freedom. Any person has the ability to make a contract. Okay, so the four basic elements of forming a contract are offer, acceptance to that offer, having the intention to create a legal agreement, and then consideration to that contract. So let's have a look at those now. You see here there's a matching exercise. If you just want to pause and have a go at this, draw an arrow from each of the formation elements on the left to their descriptions on the right. So let's have a look at those. So an offer is, third way down, the starting point for creating a contract. So once this is communicated by the offeror, the offeree can choose whether to accept it or not. I like to explain to my students that an offer is simply a promise. It's a promise to sell or do something to somebody that is open then for them to accepting. So who in law is the offeror? This is a person who is making the offer. And then the offeree is the person whom the offer has been received to, and it's open to them to accept. So one of the things when you're looking at scenarios for exam practice or in your exam, one of the first things I would recommend is that you identify who the parties are, who is making the offer, and who is the offer open to accept. So acceptance is, of course, an accepting of an offer. It is usually a positive or an affirmative response to that offer. So I accept, I will purchase your product. Now, we'll see through case law, acceptance is not all about saying. Acceptance could be given through conduct, so actually performing what somebody is asking them to do. So we'll have a look at that. Intention is the intention to create a legal relationship. So this signifies the intent to enter into a legally binding agreement. We all in our daily lives make agreements with people, family, friends. It doesn't mean that we have the intention to create a contractual agreement. And of course, the courts do not want to be wasting their time figuring out domestic disputes that have gone wrong, where there was no intent for those to be legal in the first place. A usual indicator is whether money is involved. But we will look at this and how the courts deal with that and navigate those situations. Consideration, I like to call the value of a contract. Every contract must have value and it must be mutually exchanged. So each person, the offeror and the offeree to a contract, they are both giving something up but also gaining something in return. So money in exchange for goods or services, for example. So this is the mutual exchange of something, usually money, but the courts have looked at cases where the consideration to a contract is a bit more tricky and not involving money. Okay, so how is a contract formed? So an offer is communicated by the offeror to the offeree, and the offeree then chooses whether to accept that offer. The first point to be noted, which if you are writing a summary of these legal principles, this would be my first point that I would note down under a heading that says offer. The first point would be an offer must be definitive and clear. So it must be clear that the offeror is making an offer. And there are two cases that really nicely establish this, I believe. You've got two cases about claimants who wanted to buy their local authority or council homes from the council. So you have Mr. Gibson, who wanted to buy his home from Manchester City Council, and the council said to him in a letter that it may be prepared to sell the house to him. So then when he made his full application and it was rejected, he tried to sue the council for going back on the contractual offer. But it was held by the court that the council's letter was not an offer. That wording was not clear enough to constitute an offer. If you look up the case of Storer against Manchester City Council, you'll see that the wording is different in terms of that sale. And the wording there was agreement for sale. The letter was headed up with that, which indicates more to anybody that that is a formal offer for sale of the property. So he was successful in his action. Okay, so one of the key things, certainly in scenarios and a discussion point in essays, is how easy is it to identify whether an offer exists? So as I said before, an offer is a promise to do something. How easy is it to identify whether somebody is promised or whether they are simply responding to perhaps a request for information? And I believe nowadays, certainly the lines are blurred because a lot of us do online selling. And a lot of these cases actually don't cover instances of whether offers or when offers are created during these transactions. So, the area does need updating. That would be one of my suggestions for reform. We need some more rules around online marketplace selling, if you like. So the kind of two key cases that you need here to help you with identifying whether an offer exists is the case of Carlisle against Carbolic Smokeball and Company. And that was an old case, you see, 1893. And then we have the later case of Fisher and Bell. Both of these were, as it was then, the House of Lords. These were key cases. And what we're going to look at is which one was held to be an offer and why. But these really have shaped the area of law. So I would say these are the two key cases that you need in this area, certainly when identifying whether an offer has been made. One of these cases decided that a seller is not offering a product to you, even if it is on display. Now, I've said to my students that certainly before I started studying law years ago, I used to think that if I went into a shop and there was a product on a mannequin for sale in the window, that I had the right to buy that. I felt that that was an offer for sale. So imagine if you go into a shop and an item that you want is gone, but the last one is in the window on display. Would you have the right legally to buy that? And in actual fact, you don't. The products that are on display are not offers for sale. And this is kind of one of the key principles that we need to be aware of. Okay, so let's have a look at these in more detail. So Carlisle against Carbolic Smokeball. I'll give you a brief overview of the facts, then you can write some notes. Please do feel free to pause and use this tutorial as works for you best. So Mrs. Carlisle saw an advert in a paper, which actually I showed you a screenshot on the previous slide of that advert, which was the promise of a flu cure. So this was a company, bearing in mind flu is a really serious illness. It kills people now, but imagine how many more people it killed over 100 years ago. So this was a company that was promising to cure flu if you bought this smoke ball and inhaled it. So Mrs. Carlisle bought this smoke ball and she used the smoke ball as directed, but she still caught the flu. So this company, in their advert, as we often see nowadays, said that they would promise a reward for anybody who bought the smoke ball and it didn't work for them. And that reward was going to be £100. Now, that is a lot of money in the late 1800s. You could probably find out exactly how much using one of the online tools. But to show their seriousness in this, they deposited £1,000 into their local bank. So they were really encouraging people to take up their offers, should we say. So Mrs. Carlyle used this smoke ball and it didn't work. So she sued them. And this became a really important case. It went all the way up to the House of Lords because the issue was, of course, from carbolic smoke balls point of view, they hadn't made an offer. You know, this is an advert. They called it back then an advertising puff. And also think about the implications of making an offer to multiple people. It really, means that if something goes wrong, you're having to pay out a lot of money. So Mrs. Carlyle, in the end, was successful. The court said, and I've got the outcome here for you, a contract was created between the smoke ball company and Mrs. Carlyle. They had made what they call a unilateral offer to anybody who wanted to accept. So that's quite a critical decision, really, saying that you can make an offer to anybody in one sweep, if you like, in one act. Usually, contracts are what we call bilateral offers. They're made between two parties, either businesses and or individuals. But what this case did was widen the parameters of that and say you can actually create a contract or make an offer to the world. And anybody who wants to accept can do so. And the House of Lords, in their obiter of that case, other things said, gave an example of if somebody lost their pet dog, for example, and they put a reward poster up, that could be an offer open to anybody who wants to accept that offer of finding the lost pet through obviously conduct of trying to find the pet. And it's only once you find the pet, you take that pet back to the owner, that you would then receive your reward. So that is what they said would be acceptance via conduct. You wouldn't expect people to come and knock on your door and say, hello, I am about to go and look for your pet now. You would expect them to just look for your pet. So the conduct, and in Mrs. Carlyle's case, the conduct of her buying the smoke ball was her acceptance. So a contract was formed. What they also did, which is interesting, is they relied on other elements of formation to make their decision as well. So these are all very fluid, if you like. The court said that the company showed intention to create a legal agreement when they deposited the money. And of course, that money was evidence of consideration, value to the contract. That £1,000 showed their intent to be serious. So therefore, a contract existed. If we look in contrast, so we had this then, so go back to Carlyle, we have this landmark decision in 1893, and then I imagine there was some panic among businesses trying to, scrap their adverts and make sure that they weren't making offers with the world and tying themselves into payments that they couldn't make. So that was kind of the next 60 years, if you like. And then we had the case of Fisher and Bell, and I think this kind of had to happen to rein some of these cases in. So Fisher and Bell, actually, please do read the facts on this because it's a really interesting case. It started out as a criminal case. The defendant in this case was displaying a flick knife in a shop window. It had a price tag on it, and he was arrested for offering an offensive weapon for sale. Now, his defence, if you like, his argument was that it wasn't for sale, it was simply in the window. So this became a contractual dispute, which is why we teach this case in contract law. And again, this went up to the House of Lords, and they decided that this flick knife in the shop window, despite having a price tag, clearly, let's be honest, for sale, was not contractually an offer for sale. They created a new phrase called invitation to treat. So they said that this flick knife was an invitation to people to come in, discuss, maybe negotiate with a view to making an offer to buy the knife. So at the stage that it was in the shop window, nobody was in a contract. And as you'll see from other cases around this area, what this case kind of did was then spur on other cases to follow this principle. So there's a case involving the Boots pharmacy, where they said that products that are on the shelf are not an offer for sale. The offer and acceptance only takes place when you take that good to a till and you exchange money. So this really had a big impact on how businesses work and when they create contracts. So exam questions may ask you to identify whether an offer has been made through a scenario or to evaluate whether the meaning of an offer is clear or unclear. So some people may feel that this difference between an offer and an invitation to treat is actually unclear, especially for lay people, because as I say, before I started studying law, I would have thought that something in a shop window or on a shelf or in an advert would be an offer for sale, but actually we're being told through case law now that they are invitations for us to treat. So I've got these key phrases on the slide here for you to write down. So we have what the meaning of an offer is, invitation to treat, and then you've got kind of one step back from these, really, the inquiries. You may simply be requesting information and not even at the stage of negotiation or discussion. And I liken this to kind of what happens on those online selling platforms, if you like. The classic question, is this still available? You know, that's an inquiry. At no stage there are you then entering into discussions or negotiations. But when you start talking about price, that's when we look at our invitation. Would you accept £20? And actually, the offer and acceptance does not take place until there is that exchange or that definitive promise and acceptance between the two parties. When you look at buying and selling houses in our legal system, we operate a very similar model to this that I'm teaching you, because you would think when you go and look at a house to buy it and you make an offer through an estate agent and that offer is accepted, you would think at that point you're in a contract. But actually, contracts are not binding until later on in the process through your solicitors. It actually happens typically 10 days before you move. So it's a really interesting area. But what I would say in an exam scenario, look out for the words promise. And of course, if an offer and acceptance takes place between two people, then that's going to be a lot easier to establish rather than identifying whether an offer can be made to multiple people and how that is to be accepted. Okay, so looking at the rules around acceptance, of course, you must know that an offer exists in order to accept it. And the key case here, again, note the age of these cases. This area is extremely old. Taylor and Laird. So this was where somebody believed that they were working as a crew member in return for wages, but they didn't actually let the ship owner know that they were going to be working. So there was no offer here of work in exchange for money. Acceptance can only take place whilst the offer is open to them. And a key case here to look at is the case of Dickinson and Dodds. So the offeror is free to withdraw their offer any time up until acceptance. And what this case also says is that offers can be revoked via third parties. So you don't actually have to ring up the offeree and say, I'm withdrawing this now. If you can communicate that withdrawal of an offer in a reliable way, then that could be effective revocation of that offer. The problem becomes if consideration has been provided for that offer. So let's say somebody pays a deposit for you to keep your offer open. You know, you want to go and buy a car and you say, I like that one, and you leave a deposit. It means then the offeror would be more obligated to keep that offer open to you because you've provided consideration for that offer, if that makes sense. So do keep a lookout for that because that can be quite a common issue that crops up in scenarios. So an offer typically ends when it's accepted, and then of course we have a contract forming, but it can also end in other ways. So an offer can be revoked, that I've just kind of talked about, withdrawal or revocation. It can be rejected, time could lapse, so the offer just simply goes, or maybe one of the parties dies, in which case the offer would naturally revoke, unless somebody else can take it on. So have a look and spend a few minutes here at looking at these cases and put those ways of ending an offer where you think they would be. So revocation, rejection, there is silence here, and there's also lapse of time, and then there's death as well. So I will move on to the answers when you're ready on the next slide. Okay, so here are the answers here. So you see an illustration of withdrawing an offer is Routledge and Grant, but also you could use Dickinson and Dodds here instead if you wanted to. Rejecting an offer comes from the case of Hyde and Wrench. Please do look at this case because this shows if you make a counter offer in response to an offer, that academically, contractually ends that original offer. Yeah, so it could be I offer to sell my phone to somebody for £500. Someone comes back and says, I would give you £400 for it. Well, that technically then ends my original offer academically. So that person, if I then said no, I won't sell to you for £500, that person then can't sue me in court and say, well, they should have sold to me because my original offer has gone. In terms of time lapse, there's not really a particular time as set by the courts. It really depends on every case. But you see, in this case, one where the claimant wanted to buy shares, you've got around 5 months here, but there isn't a set time. Silence obviously will not constitute acceptance. That comes from Feldhouse. And then potentially death of one of the parties to the contract ends the contract unless, in this case, you can pass your obligations on to your estate once you've died. Okay, so we're going to move on now. So how is acceptance communicated? It's kind of key to look at this. It must be positive, and it can be in any form, but silence will not suffice. It can be, as we know, by conduct, when we think about our original key case of Carlyle. So hopefully these bullet points help you in terms of setting out your notes for principles of law. And then you can look at this table, which illustrates different methods of communication of acceptance. So we've got acceptance via post on the left-hand side. Now, post is a little bit outdated, I would say. Not many people communicate contractually via post anymore. Having said that, solicitors, I would argue, still do. They're probably some of the only businesses left that do. Banks tend to do a lot of things online now, but some banks may send agreements through the post to you. So the postal rules of acceptance come from an old case again, Adams and Linsell, which is about selling wool to somebody. The key rules are in the second box. Acceptance takes place at the moment of posting it. So if somebody makes you an offer and you want to accept it, the moment you put that letter in the letterbox or hand it over to the post office, that is acceptance there. So that's quite scary, isn't it? Because offerors can be in a contract without even knowing it until that letter reaches them. It's really interesting area that for discussion. But there are three criteria for this. So post must be the expected means of communication, firstly. Secondly, the letter must be properly stamped because, of course, it may not reach the offeror if it's not. And thirdly, there must be proof of postage. So this could be a receipt, for example. So then the other side kind of falls to more common everyday ways of acceptance, so electronic or what we could call instantaneous methods of acceptance. So typically, acceptance via these means takes place when the offeror receives that acceptance. Now, we've got some cases underneath which illustrate what happens if somebody accepts your offer at 2 a.m. and you're asleep. So there's a solicitor's case here, you see. They say that acceptance takes place when it is reasonable to expect the other party to read it. So in this instance, the court would look at the particular parties involved, okay? So if you send an acceptance when a business is out of hours, for example, then that acceptance is only going to take place when open, okay? So in summary, for instantaneous methods of acceptance, they take place when received, but only when reasonably expected to be received and when opened. And I don't know whether you knew this, but via email, sometimes you can request a read receipt, certainly through Outlook. So you could actually, if you're accepting an offer, have a receipt of that acceptance. And we have some consumer regulations that offer protection if sellers or offerors leave out key information in a contractual offer to you, then even if you accept it, you would not be bound by that. You would have an avenue of suing or compensation, if you like. So I hope that those rules make sense for you. We're going to move on now. And I've got now some independent tasks for you. You can maybe take some screenshots of these and have a go at them just to help you kind of consolidate your notes. So there's a summary task here with fill in the gaps and some words at the bottom that might help you. And then there's some research here of some key cases, certainly for offer versus invitation to treat versus counter offers versus inquiries or requests for information. So please do take a screenshot of those if you want to have a go at researching those. I believe on the OCR website there are some there's a document with some of these key principles in, if you can find it. And just to help you in terms of structuring an answer for a scenario, I always recommend to my students to use the scenario to identify what's happened in chronological order. So you need to first of all identify who is the offeror, who is the offeree. Make sure you understand what the question is asking you because OCR are quite specific in what they need. So the first thing would be, is the wording clear? Is this an offer? Is it a promise? Or is it an invitation to treat, an inquiry or a request for information? So use the case law to help you inform that decision. What type of offer is it? Is it bilateral or is it a unilateral offer? Is the offer open to be accepted or has it been withdrawn? Has it lapsed? Has a counteroffer removed the original? Was there consideration given to keep that offer open? And the Dickinson and Dodds case is important as well here. So then you can conclude whether there's an offer or not. A conclusion is always important at the end of each part of the scenario that you consider. Okay, so have a look at this scenario for practice. This is a good one to start. It is it was on a previous practice paper for OCR, and you see you could set out your answer in two paragraphs, if you like, because you need to advise whether there has been an offer and acceptance between Dylan and Ella, first of all, and then Dylan and Wendy. This was actually an old 25 marker, but now we know we work to 20 marks. There isn't a huge amount to write in this, and that's what I think students sometimes panic about. They feel like they have to write pages and pages, but it really is in law what you write rather than how much you write. And remember, to gain the AO1, the law knowledge of law marks, you must explain your points, use relevant cases, and then apply. So please take some time and have a look at this, make some notes on it, and then I'll take you through the key points on the next slide. So with Dylan and Ella, you could say Dylan's offer was clear. An offer remains open until revoked or accepted. And of course, revocation must be communicated, but can be communicated via a third party if effective. So we know that Ella has seen the picture being sold to somebody else. The question is, does this amount to effective revocation? Because she's seen it, we would probably say it has. And there was no consideration given by her, so there was no incentive for Dylan to keep the offer open to her. So we can conclude there, no contract, no offer or acceptance. Or if you conclude that revocation is unclear, then you might conclude that Ella has accepted. So you see, I give you a bit of an alternative here, and it's kind of really important to understand that you're given marks for a reasoned conclusion. You may not come up with the same conclusion as the person next to you, and that's usually okay unless it's absolutely clear and there is really only one outcome. If you use reasoning and you maybe come to a different conclusion, that really isn't going to be a factor that impacts your mark. So in terms of Dylan and Wendy, obviously Dylan's offer was clear again. Acceptance was communicated and effective instantaneously, really, during the phone call. So we would say his revocation is ineffective because it can't take place after acceptance. You can only revoke or withdraw an offer before acceptance. So Dylan is in breach of contract. There is offer and acceptance there. So I hope that makes sense to you, and we can have a look at another scenario. So here is the most recent scenario, which involved students advising whether there is an offer and acceptance. And this was from the summer 2022 paper. So this involved 3 potential communications, and students needed to say whether there was an offer made first and then whether acceptance had taken place. So if you have a look at this and pause for a minute, just make some notes and decide whether there is offer and acceptance between Nina and James, Nina and Mia, and Nina and Beth. And then on the next slide, I'll run through the key points with you from the mark scheme. So I find the mark schemes, particularly with OCR, really helpful because they set out suggested points and just kind of give you a bit of a structure. So obviously you can set out your answer once you've given your key learning AO1 principles. You can then set out your structure in 3 paragraphs dealing with each of those communications. So the first thing is whether between Nina and James we have an offer. And you see in the first one, it's more likely to be an invitation to treat because it doesn't contain a promise. And then you could consider whether an offer's made, but hasn't been accepted at that point. So there isn't a binding contract. So you see what you're doing structure-wise is just picking out the relevant points using the scenario as your structure and as your guide. With Nina and Mia, identifying that a bilateral offer's been made and a promise to keep the offer open. However, there's no consideration to that promise, so Mia can revoke that offer at any point. We have a selling of the goat to somebody else, and that communication has been done via a third party, which we know from Dickinson and Dodds can be done. So there's no acceptance because the offer has already been withdrawn or revoked. So there is not a binding contract there. And then the final one between Nina and Beth was just testing your understanding of acceptance, really, because the acceptance has been made in a different way to that which specified. So obviously there had to be notification in person for the acceptance, but Beth did not say that it absolutely had to be that way. So I think this was the more difficult one, because students received a mark if they mentioned that the fact that Nina texted instead as acceptance, that would not have disadvantaged Beth in any way, rather than going to see her in person. So there is case law out there on this. There is a Catholic Church case that you could look at where they talk about acceptance in different methods. Obviously, if you're going to accept something in an instantaneous method in the same way, then that could still be seen as effective communication. So it's just worth bearing that in mind. So I hope that that helps you, and what you could do is practice writing that out, the relevant law. I feel that with contract law scenarios, the best way to do it is to deal with each issue at a time, state the law principle, and then apply at the same time, because otherwise what you end up doing, and I think certainly in the last exam series, examiners found this, that students tend to write everything they know about an area and then they apply, and the application becomes less so because they run out of time. So the best thing to do is to use the scenario as your guide, identify what the relevant law is, write that relevant law down, and then apply it, and then move on. Okay, moving on. So what I would say is, of course, first of all, thank you for listening. But practice is really important here, certainly with these formation elements. For the OCR specification, you have the potential, not just scenarios, but also essays. And I will do an evaluation tutorial on offer and acceptance as well. But please make sure that you write out your learning points and then have a think about what the potential issues of clarity could be. Obviously, throughout, you may have thought, oh, that's not overly clear to people. For example, the difference between an offer and invitation to treat. So try and think of those evaluation points before you watch the tutorial. And in my next tutorial, I'm going to cover the other formation elements, which are intention to create a legal agreement and consideration. So thank you for listening.